The violation of Akube Ndoromo's Fourth Amendment. The government on December 22nd went to Akube Ndoromo's apartment with seizure warrant. Mr. Ndoromo, the government knocked at the door. When Mr. Ndoromo was trying to check who was that knocking the door, the government forces their way in and had Akube Ndoromo under handcuffs for 2 hours. The handcuffs was taken out, but Akube Ndoromo was to be interrogated, was not allowed to answer the phone or move. And this seizure happened to Akube Ndoromo on December 22nd, 2004 at around 5 a.m. You can see Johnson versus Cambell. The seizure found when officer persists in demanding that person sitting in parked car roll down the windows after person initially refused to do so, and it became clear that persons sitting in parked car roll down the window after personally initially refused to do so, and it became clear that person could not refuse officer's request. Also see Kamp versus Texas. Seizure found when circumstance surrounding encounter with the police leads reasonable person to believe he or she is not free to ignore the police and go about his business. And you can also see Kimmelan versus Morrison. Quoting Stone versus Powell. He was corpus relief available, although basis for ineffective assistance claim issues was counsel's failure to object to admission of reliable and exculpatory evidence seized in violation of Fourth Amendment. Akube Ndoromo has the right to be secure in his apartment, papers and effects against unreasonable search and seize. No warrant shall issue but upon probable cause, supported by oath and particularly describing the places to be searched and the person or things to be seized. The government violated the search and the seize warrants, seizing the following: Voice of Social Concern Association Tax Report for 2001-2003. Voice of Social Akube Ndoromo's mother's approved visa to migrate to United States. Akube Ndoromo's fiancé visa approved visa to United States. Mr. Ndoromo's income tax reports for all these years. Mr. Ndoromo's medical records. Mr. Ndoromo's old passport. Mr. Ndoromo's personal notebooks and diaries. Mr. Ndoromo's cash $600 in his wallet, personal wallet, and the banking accounts, leaving him without any money to buy food, rental funds, or gas. He became homeless, eating using food stamps until now. Seized all the Voice of Social Concern records and the Voice of Social Concern non-profit records. The government generally was not supposed to exceed the terms of the authorizing warrants, making or conducting a search and a seize. In addition, the Fourth Amendment that government actions in the execution of warrants be related to the objectives of the authorizing intrusion. If executing officers exceeded the scope of a search warrant, the seized evidence must be suppressed and the entire case must be thrown away. See U.S. versus Pashola. Evidence suppressed because executing officers exceed scope of already overbroad warrant. Authorizing seize of women's clothes by seizing 2 racks of men's clothes. Also see U.S. versus Coleman. Evidence suppressed because officers exceed scope of warrant, authorizing seize of certain financial record by seizing materials not included in warrant. Also see U.S. versus Schroeder. Evidence suppressed because officers exceed scope of warrant, seizing trailer of adjacent to property indicated in warrant. Even if some documents seized were within the scope of warrant, authorizing seize of records of defense business that tended to evidence healthcare fraud, the conduct of the agent who executed the warrant was so inappropriate as to warrant exclusion of evidence seized. One agent, Brian Evans' testimony was unequivocal in his belief that they did not consider themselves to be limited to seize business items in healthcare only, or records that tended to show evidence of violation of the healthcare fraud statute, and in fact indicated that they intended to seize personally financial records as mentioned above, and they didn't intended to limit financial record as mentioned above, and they didn't intended to limit the financial to business record in healthcare fraud. An unlawful search or seize neither precludes prosecution nor invalidates a subsequent conviction. Instead, usually remedy for a Fourth Amendment violation is suppression of all illegal seized evidence. The Fourth Amendment also protects against unreasonable government seizures of personal property. Seizure of personal occurs when, in a view of all of the circumstances surrounding the incident, a person reasonably believes he or she is not free to leave an counter government official, like in the situation of Mr. Ndoromo. The government court and the defense counsel conspire to convict Akube Ndoromo, to lock him up, to cancel or to conceal their robberies. And in this situation, the judge personally is helping the government to cover up the government robbery of the bank accounts, of his money, even in his pocket when they are seizing with the warrant. And not only that, he went so far of mentioning that because he is not from here, he's an immigrant. That's why he say he always give what about Akube Ndoromo's national origin. He always give that, whether the person is right or wrong. Since he's an immigrant, he will be automatically wrong, according to Judge Imadi Salban. Thank you, and I will also add, I will put this copy will be in the YouTube, and you can also see in Facebook, Justice for James and the Stop Government Robbery. Thank you.